Welcome to Public Affairs Roundtable, a discussion of current events in the nation and around the world and how they affect the people of Indiana. Here's your moderator, Larry Lough.
How do we get federal judges and how do we get Supreme Court justices? The federal judiciary has been in the news recently, names such as Rehnquist and Mannion on the front pages. Today on Public Affairs Roundtable, we're going to talk about the process, a political process of nomination and confirmation. Our panelists are three members of the Faculty of Political Science Department at Ball State University. From your left, Ray Lough, Sally Jo Vasico, and John Rouse. Sally Jo, the federal judiciary is different from anything we know of on a local or state level. Why is it different?
Are you referring to the nomination as opposed to the election process?
As to how we end up with federal court judges and Supreme Court justices.
Well, under the Constitution, Article 3, Section 1, the judiciary, the Supreme Court, is established along with all other inferior courts that Congress wants to establish. And with that proviso, Congress has set up a district appellate court and Supreme Court system whereby the judges are nominated and confirmed, nominated by the President, confirmed by the Senate, and they are appointed for life. And I can anticipate why are we doing that, because I get that question a lot from students, and it is the Founding Fathers, in their wisdom, decided that they wanted to take the judiciary out of politics. And so we have this particular process.
We've taken the judiciary out of politics, but that's not really the case. This is a political process, isn't it?
They're part of the political process. The out of politics consideration was really the life appointment, so that they would really, unless they were found for bad behavior, and that's another section of Article 3, they do have life appointment to the Supreme Court and to the courts of appeals and to the district courts. And that's so that they would not have to stand for election, and they could make their decisions based upon the law, the interpretation of the Constitution.
Ray Lough, the nomination process and the confirmation process are both very politically oriented, are they not?
Sure. This is where politics indeed intrudes into the entire selection of any justice from the district court up to the Supreme Court. This is the only time the elected officials, that is the president, number one, in nominating, but number two, the U.S. senators, have a real chance to grill these people, because once they're appointed, they're gone for life, and they're sitting across the street in the U.S. Supreme Court building. In that sense, this is where the political pressure is the most intense, is in the confirmation hearings. And what we've seen with Dan Mannion, who's from Indiana, of course, here, President Reagan's nominee for the appellate court out of this Midwest circuit, and also in Rehnquist and Scalia's nominations, as we're seeing the U.S. senators bore in from the political standpoint to find out what these men are likely to do once they have these life appointments.
We see these people, I guess, warts and all, too. I mean, we find out every detail of their lives. I mean, that's not necessarily bad, is it? That we get full disclosure on these people and what sort of restrictive covenants they had on their homes, and there's nothing we don't find out about these people,
is there? It's interesting to note that really this boring in, as you're talking about, reached its full, I suppose, initiation during the 40s with the FBI doing a check, with the role of the American Bar Association, with, of course, other groups coming in to offer testimony as to whether or not a particular person should be elevated to any kind of court. And, of course, we've had rejections by the Senate. I mean, it's not an automatic process that just because someone is nominated that the Senate will automatically confirm them. We've had recent history of rejections both on the Supreme Court as well as, of course, in the 30s with regard to the appellate courts.
But let me interject something here. What's interesting with respect to the Senate hearings with regard to confirmation of these justices is that kind of an undertone of most all of these is the way in which this man or woman, that's the nominee, is likely to vote down the road.
Yes.
And as a matter of fact, we have probably as many precedents, Sally, do we not? People that you would think you could predict the way they would stand on a particular case, but they end up 10 years after they're on the bench not voting that way at all.
Well, right or wrong, you know, the way the a president's legacy can often be seen in his court appointments, whether it's a district court, court of appeals, or Supreme Court. And so obviously every president wants to leave that kind of legacy in the sense of perhaps his political philosophy on the courts. I mean, we've seen that since the inception of our country. And you're right, presidents have not always been able to predict, and of course the prime example is Earl Warren. Everyone thought he would be very conservative based upon his time as Attorney General, as Governor of California, and so on. And he was predicted to be a conservative justice. Well, of course, if you believe in labels, he's certainly not been labeled conservative. He's been labeled a liberal activist.
Recognized as the most liberal, isn't he?
Yes, and the most activist in the sense of the judiciary.
Sally and Ray, I was coming back from a camping trip recently, and I did an unofficial Rouse survey on the radio. And my survey said that the American people, according to what I got on the radio at least, care most about fundamentalist preachers, red baseball, and rock music. And there was nothing about judicial appointments or politics or public policy and what should be public policy. My question for you folks is, does anybody out there care about these appointments?
When you start affecting people's lives, they certainly do. You have to look at the impeach Earl Warren signs, and that goes back to Brown versus the Board of Education. It goes back to what was perceived as being soft on communism. Yes, when your ox is being gored, you certainly do end up caring about who's sitting on the court.
Sure. Let me say in that same response, John, the fact of the matter is the U.S. Supreme Court is a policymaker. So at the eye of the storm of a lot of the so-called social issues in America today are U.S. Supreme Court decisions. So as a matter of fact, the people may not really care about any one piece of evidence that emerges out of a Senate confirmation hearing, but as a matter of fact, they do care about issues such as abortion. They do care about civil rights. They do care about many of these public policies that are decided in the courts.
What was it about Daniel Mannion? Let's take that as an example that brought about such controversy. I mean, he had a conservative background, not a necessarily distinguished legal career up to this point. What was it about this guy that caused such controversy?
Well, several things. Number one, he was at least part of a family, okay, that is viewed as being not just conservative, but extremely right-wing. His father was dean of the Notre Dame Law School for years, established, some of our viewers may remember the Mannion Forum, which was a television discussion show that was hosted by Dean Mannion of the Notre Dame Law School, and it was very right-wing. He was one of the founding members of the John Birch Society, for example. And now his son, Daniel Mannion, of course, has come along, was elected to the Indiana State Senate, and had a fairly undistinguished, as you pointed out, 4-year, one term in the Indiana State Senate. Was probably most famous for promoting different policies that were seeking to overturn Supreme Court decisions, such as the posting of 10 commandments in schoolhouses, public schools. So consequently, Mannion really didn't have much of a judicial record. Well, in fact, he had none to speak of, other than being a lawyer in I think 5 or 6 federal cases was all. So consequently, the fact that he was an extreme right-winger, that is, named Mannion, coming out of that environment. Number two, the fact that really his public record was not all that distinguished. I think some of the members on the Judiciary Committee, primarily the Democrat-liberal element on that committee, decided to go after Mannion.
Why does a president nominate a guy like this?
Well, if you read, according to some of the articles in the Muncie Star and other papers, because Mr. Mannion reflected some of the views of the president in the sense of philosophy, and he is, as we were talking about earlier, wants to put people on the court that reflect that philosophy. He's not any different than a Roosevelt or a Truman or Kennedy or Carter at the lower level. Of course, he didn't have any Supreme Court nominees.
But Nixon.
Or Nixon. Yeah, I mean, all presidents have done that. Yeah, it's not just Democrat or Republican. All presidents have done that. One of the things, though, that I think we need to bring up in the process, as you were talking about it earlier. There's often been a question in the literature as to whether or not a nominee to any court should have prior judicial or even prior political experience, in the sense of bringing somebody to the court that has a good, wide background as far as the public process or the public policy process. And there's been a question with Mannion as well as some others. He had no prior judicial experience. And I think at some points in our history, we've introduced legislation to demand that Supreme Court justices, as well as other justices, have this kind of experience. Now, they have not seen the light of day, obviously, but that's been a consideration. And if perhaps in the sense of Mannion there was a prior judicial experience, you could see more completely where he would come off on certain issues. But then, as we were talking about earlier, even some with prior judicial experience have not always proved out to be politically, at least on the court, in the sense of some of their policy decisions, as predictable as we thought they were going to be.
Sally, to dovetail on that particular discussion, tell us, first of all, in terms of course, Daniel Mannion was appointed to or is going to be appointed to the 7th Court of Appeals. Why, first of all, is the 7th Court of Appeals important in terms of the entire judicial process or the court system?
Well, it's that middle layer. You have the district court, and then cases from the district court are appealed to a court of appeals and then on to the Supreme Court of the United States. And most district courts are 3-man judges, or they can, the whole court of appeals can sit in on an opinion depending upon the nature of the case and whether it's called for. But they're that middle tier, and a lot of decisions, quite frankly, are not appealed, and therefore those courts have a really important public policy role because their decisions stand. Or if, for example, an opinion or decision is appealed and the Supreme Court does not grant certiorari, then that lower court opinion stands. So they're very important as a middle tier, if you will, policymaker, and the fact that many opinions are not appealed. Mm-hmm. And if they are appealed, they're not granted certiorari, and they stand. If
I could follow up on another question, both you and Ray talked about professional criteria for judges versus politics. The Democrats were saying that no, they were not against Mannion because of politics. They didn't like his professional criteria. The Republicans said it was politics, and so the vote was 49-49. Is there any way possible to distinguish for the citizen who's looking at this and not really politically focused on this issue between professional criteria and politics?
Well, this whole thing is involved in a political process, mm-hmm. And it's difficult. You can legislate, for example, that anybody appointed to any kind of federal court have these certain qualifications. If you go back to the Mannion, the ABA gave him a qualified, as opposed to extremely well qualified or other divisions of description, for want of a better term at this point. You can do that, I suppose. We've talked about it, but we haven't done it.
See, no one has a crystal ball on future behavior of anyone. It's more or less like looking at a credit report for somebody. Okay, here you get a 10-year credit history on somebody, and you say, well, you've paid your mortgage payments, okay, you've paid your utility bills, okay, but you were late on your car payment a couple of times, but you paid the rest of your bills, okay. Then you got to look at that overall credit record on someone, and you got to say, now, if I'm going to loan him more money, is he going to pay it or not? That's essentially what we're doing in judicial nominations, is we're taking a look at this record that these men or women, if it were a woman nominee, may have over 10 or 15 or 20 years, and we're trying to say, well, now, how likely is it that they're going to do what they've done in the past? And as we previously mentioned, that's just like a credit report isn't always accurate or a good predictor of what may happen in the future. Past records of judicial decisions, past experiences, not necessarily a good indicator either. It depends on the individual. And let me illustrate that in another way. Especially for the U.S. Supreme Court, when a man or a woman becomes a U.S. Supreme Court justice, they must suddenly start understanding, and almost all of them do, that they are no longer just ideologues. That is, they no longer just have this belief or an ideology that they're going to write into every opinion. they suddenly start understanding that they're one of 9 people of the highest judicial institution in the country, and slowly but surely it starts creeping into their mind that they better bring a point of view for protecting that institution. In Rehnquist's confirmation, one of the senators, Democrat senators, asked, well, as Chief Justice, would you attempt to build a majority, even if that majority decision, or unanimity, even if that unanimity was against your ideology, against your belief? And Rehnquist answered, yes, sometimes for the court I would compromise my beliefs, but only to strengthen the court as an institution. Consequently, we don't know whether Rehnquist will be consistent down the line as Chief Justice as he was as an Associate Justice, because now he's the leader of the other 8. And consequently, he may have to give a little bit here and there because he's now viewing it from a different perspective. So predictors are not, you can't always lay it out and say, well, I'm 100% confident.
You know, I think the emphasis should be made that we are indeed talking about justice. And these guys, I don't mean to be sexist, because it's eight males.
We're
and one
working on
female.
that one.
Okay,
Yeah, we're
correct,
trying to get some more in it. Yeah.
Okay, now what was I going to say?
Justice.
These people on the court, they are the highest, most recognized people in the whole country about telling us in this nation what is justice. And when we're all thinking about that issue in our daily lives, we have all these small injustices that occur to us. They are the ones that really talk
Eventually
about justice.
would decide such an issue if it ever got to that level.
But these people are professionals in that field, too, in law, that they've studied it, that they've practiced it, that they are, in fact, perhaps lawyers, jurists first, and politicians, although we look at the political angle of it in the confirmation hearings, they're politicians second.
Well, I think it's interesting to note that there's no place where it's written that one has to be a lawyer to serve on the Supreme Court of the United States. And that's just one of those customs and traditions that we've started. In fact, throughout our history, there have been attempts to appoint even a political scientist. Talked about, I mean, it's not seen the light of day, but talked about appointing a non-lawyer type to the Supreme Court, and you would have to have such impeccable credentials to be a non-lawyer type to be the court that I don't know that we'll see that. But I think it's interesting. We assume that they all should be lawyers by the nature of the subjects that they deal with. This question of what is justice, and what, it raises a larger question of the role of the court, of course, in interpreting the Constitution and interpreting those the provisions in the Bill of Rights dealing with specific aspects of justice and the backgrounds of these people. And I want one thing, while I've got the floor, I have to keep it or else I'll lose it for sure. But to illustrate what Ray was talking about in the sense of the role of the Chief Justice, I think to look at what Earl Warren went through to get a unanimous opinion that he wrote in Brown versus Board of Education. He wanted a unanimous opinion. He did not want any dissenting opinions because he knew the magnitude of that opinion. In order for it to be accepted, or at least to be enforced, and he knew there was going to be a lot of criticism, but there was a number of drafts opinions that were circulated. And he actively, based upon the records that we have of that court, he actively went after both Justice Jackson and Frankfurter, because they seemed to be the two that were questioning on a states' rights issue, and circulated these drafts. And not to belabor this, but he did play a leadership role in getting a unanimous opinion. Now, oftentimes during the Warren Court, he could not get a unanimous opinion, such as in Miranda, it was a 5-4 decision, but he wrote it. He was, so the role of Chief Justice is important.
I also think it's worthwhile for us to look at some of these issues that the court may be addressing. We mentioned the issue of abortion. Another issue, of course, is the issue of race and quotas and affirmative action. A third issue is the issue of free speech, and both appointees, Scalia, I believe his name is pronounced, and also Rehnquist, tend to have anti-press views and anti-media views. And a fourth issue, of course, in terms of trends in society, might be the issue of religion and what's going to be the role of church and state. You know, as we look at these appointments, and they, of course, have not been approved yet, abortion, race, free speech, and religion. So I asked that question earlier in terms of the Reds in baseball. Maybe these things do have more importance than we give credit.
How long is this program? A half hour? Do you want to deal with all of those issues and what the court's going to do with them, John?
Well, let me put it in a little different perspective. Those are the issues that perhaps are on the public agenda today. But as a matter of fact, when we say, when we take a look at a Mannion or a Rehnquist, and we say, well, how do you stand on these particular issues? 10 years from now, there will be other issues on the public agenda that the court is, and perhaps what is a conservative position today is suddenly the liberal position in the 1990s. As it has been, as we've seen those issues develop from the 50s to the 80s, or from even the 60s to the 80s. So that when you try to pinpoint somebody, a man or a woman, and say, are you a conservative on abortion? How would you vote on abortion? As a matter of fact, the whole abortion issue may change because of changing society. New issues will be brought up within the abortion context. So again, it goes back to the fact you can't really predict and pin these people down. What may be a conservative issue today is suddenly a moderate or a liberal position 10 years from now. And they're there forever.
And the thing we have to emphasize is of the three branches, the courts are passive, aren't they? You know, in other words, they do not have any control, from what I understand at least, of what is brought before them. So they don't know for sure what particular case or the nuance of the case may be brought up.
Well, and I think in the sense of passive, remember, the court does not enforce. It takes the other branches of government to enforce their public policies. And I think that's even more critical than predicting what's going to come before them. Because without Congress, without the president, you know, Brown versus the Board of Education, for 10 years, really, we didn't have any enforcement. It wasn't until the Civil Rights Act of 1964 that Brown really began to be enforced. So, you know, as a passive, I'd be hesitant to use that too much. But one of the interesting exchanges during the confirmation hearings with regard to Rehnquist was his questioning by Senator Specter, who's a Republican from Pennsylvania, about Rehnquist's attitudes towards judicial review. You know, what is your concept of judicial review and stare decisis, as opposed to zeroing in on a particular opinion, but really focusing on Rehnquist's approach to the whole role of the judiciary, and that's, you know, another whole program, or 10 or 20.
The Senate process, we talked about the grilling of Mannion, the questioning of Rehnquist. I don't know if it's got to the grilling at this point.
Oh, it was pretty. Biden got a little excited
Joe Biden has been saying a lot lately, but the Senate process is right here. The Senate process is, in the Mannion case, Republicans said you're being political. Democrats saying we're not supposed to be a rubber stamp. The Senate process is one of advice and consent, right? What does that take in? What is the scope of that? What does that mean?
Well, that scope has expanded, I would say, in the last 30 years. To include calling in of all sorts of witnesses, FBI report, the American Bar Association. I suppose it depends upon one's perspective as to how broad that scope should be. Certainly it's not a rubber stamp, but there are legitimate questions that senators have with regard to these people and their position, their attitude, and again, trying to predict, and depending upon your own political persuasion.
Well, in the the Mannion vote, there were, whereas it was mainly party line, there were still 5 Republicans in the U.S. Senate that voted against Mannion. There were 2 Democrats in the U.S. Senate that supported him. And it was, of course, a tie vote coming down, and the vice president had to break the tie on it. It was a procedural vote that, in effect, confirmed him. Whereas politics is the overwhelming, the partisanship of the senators is the overwhelming thing that explains the way they're going to view this. On the other hand, in a very close vote, it becomes highly individualized, even in the U.S. Senate. And so you're going to see some defections from the Republican side or from the Democrat side. And it's going to depend upon, perhaps, the grilling of the witness, what they respond to in a certain question format as to whether or not a senator will be satisfied.
Oh, we do have a Republican president now nominating Republicans, being confirmed by a Republican Senate, essentially. But even when there's a Democratic Senate and a Republican president, there is an acknowledgement among a Democratic majority that, yeah, it is a Republican president, and so you don't see a lot of nominees being rejected. That, in fact, these people are essentially quality people. So there is some understanding that it's not totally politics. That, in fact, yeah, we do.
Well, I think in order to really be legitimate in the rejection, you have to have good reasons. You can't just say because he's, you know, I'm a Democrat and he's a Republican presidential nominee, I'm going to reject him. I mean, that's not going to wash with anybody. You have to have some solid reasons behind what you're questioning and why you're looking at this person. I think Kennedy, when his initial remarks during the Rehnquist hearing, said that Rehnquist was too extreme. He didn't care if he was a conservative; he was just too extreme to be Chief Justice of the United States. Now, some would call that political opportunism. Some would say, well, that's part of the process, and that, you know, Kennedy is, as a senator, is expressing the views that he has on this particular nominee. It is part of the process, and I think most of the time, the quality of the candidates have been in the past good, and some, obviously, the role of the Senate is to look at them.
You can take a look, Larry, and again, just following up on that, over 90% in every presidential administration of the people that are nominated are confirmed, and they're of the same party as the president. The overwhelming majority of these people are indeed confirmed by the U.S. Senate. Most of the publicity is attendant, of course, to the U.S. Supreme Court nominees, but even there, the record is overwhelmingly that indeed these people will be confirmed. We can name on one hand, really, in the last couple of decades, the number of nominees that have been rejected.
We're out of time today. Thanks to our panel's political scientists, Ray Sheely, Sally Jovasico, and John Rouse. I'm Larry Lough. Thank you for being with us today.
If you have comments regarding this program, please address them to John Rouse, Box 149, Muncie, Indiana, 47305. The producer for Public Affairs Roundtable is John Rouse. Associate producers are Cecil Bohannon and Bill Mosier. This program is a production of University Media Services, the Department of Political Science, and radio and television stations on the campus of Ball State University in Muncie, Indiana.